Hello, hello. I don't know if you can hear me. And what you're seeing is probably so grainy. I am so sorry. I have to be here. Ignore my apartment is such a mess right now. We're in a constant state of this is not good. We need to change. Good. Okay, audio is good. Okay. Yay, good. Hi, Ronnie. What's going on? I am just getting this situated in here. Play. Okay. All right. So I am home. I had an emergency dog situation. I am a dog sitter. And so when they call, I show up because I need to, you know. It was actually really weird. It was like a super strange thing that happened. So I don't have my camera. I don't have a microphone. I'm working off of hopes and dreams. My hair is wet. I am making ice so I can have some coffee. I'm just eating breakfast. I'm just eating breakfast. I had to go take the dogs out again just to make sure, just because I'm not like familiar with these dogs. And so I gave them one of their little bones, and it's not a rawhide, it's like a fake rawhide. But then my brain was like, you're just gonna give them a fake rawhide, like flat sort of chew and leave. No, you have to stand here and make sure they don't choke. Because I'm like a dog hypochondriac. So they did not choke. So it pushed me back a little bit in my time. But I am here. I have day 5 queued up. I will have to end the stream in a couple of hours to go check on the dogs, and then we'll start another stream to finish the day. I don't know if we're going to get to where the jury had, or oh my gosh, I don't know if we're going to get to the time that when the case is handed over to the jury, but we shall see where we get to today. And then wherever we end up, we will pick up again on Friday. And we'll finish it up, and we can hold for doggy safety. Yeah, I was like, I don't want these little guys to choke. If you see me sort of disappearing, it's probably because my cat has made an appearance and is trying to hit every button that would end a stream. So that's that. That's where we're at right now. Let's get going into this. Oh, before we do, let's run our intro because I love it so much. I love that so much. I tried all day yesterday to work on an actual outro. So hopefully I have that done by Friday. I also, when I was working on outros, I was sort of inspired to work on another intro sort of situation for Wrestling with the Business. So that kind of derailed my outro work. Lily Jack 85. Would you like to see some of it? Right now, I'm actively sort of busy. You're welcome to link your Instagram in the chat if you would like. All right, so let's get going here. Add to stage. Why is that always like, I have to change that because I don't want that to be the always thing. So they are doing their intros, asking some questions, and then they're hopping into court. I don't think it's going to be, oh, maybe there is a little bit of a moment. I think it's going to be a pretty jam-packed day. So let's see what they are up to in court today.
Tony Henderson, for sale.
Ms. Boone, raise your right hand to be sworn, please. Do you swear or affirm the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Good morning, ma'am. Could you state your name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
Ms. Boone is seated at counsel's table, buttressed by her attorneys, wearing a black suit and pink blouse. All members of our jury are present this morning. State, is there anything we need to address before we bring in our panel?
No, sir.
Defense, anything we need to address?
Yes, Judge, I intend to introduce these two exhibits that have already been stipulated to. One is, you going to walk in course of interview?
Correct.
Okay.
Right now, their ID is AB as in boy and EC as in.
Defense identification AB, Judge, which is the order dated June 16th, 2019. It's a no contact order. And then identification to AC. And it is a no contact order dated June 19th, 2019. And I'd like to introduce them into evidence. And then I'd like to hand publish them to the jury.
Okay.
And let them look at them one at a time. And then I believe we're going to rest our case, but at some point, I guess you would excuse the jury because Sarah Boone needs to be questioned about.
And there may be additional motions to be addressed at that time. So yes.
Do we want to do that now before we're ready to adjourn?
I don't have a problem with that. If you want to rest now, subject to those being entered and published, and we can address any motions. The court has reviewed both of the no contact orders. And that way we don't have to do a in and out. And I can colloquy Ms. Boone at that point in time, and we can proceed with the state's.
I owe them a big thank you. They have made my life 100% better than it was. Synergy gave me the help I needed, and that's what made me happy. What a
Rebuttal case.
Subject to those, the introduction of those two exhibits just mentioned, the defense would be resting our case at that juncture.
Okay, all right. Yes, ma'am. Okay, I've been advised by the courtroom deputy that juror wearing badge 130, seat 10, cannot stay past 5:30 today. So just be advised, and we'll use our time accordingly.
That one was the 6th.
I don't believe so. Give me a moment, and I can check. That is an alternate. It's alternate seat 4.
Thank you.
Defense, do you have any motions?
Just out of abundance of caution, I would read new or motion for judgment of acquittal, show the defense resting. I'm going to do that now while the jury is still out. I don't have any additional arguments other than what was made the other day.
Okay, thank you. Any other additional argument, Mr. J?
Just that at this point in time, the standard is whether or not a reasonable trier of fact could find the defendant guilty, and there is sufficient evidence for that to be sent to the jury.
Okay, thank you. The court recalls the arguments that were made after the conclusion of the state's case, both from the state and the defense. The court finds that a reasonable juror could make a finding of guilt on the elements of the sole charge and the information beyond and to the exclusion of each and every reasonable doubt. For those reasons, the renewed judgment of acquittal is denied. Ms. Boone, I have a couple of questions to go over with you, ma'am. You've been previously sworn this morning. Your attorney has indicated that all of the evidence and testimony of all witnesses in your case have been presented to the jury, with the exception of the 2 no contact orders pre-marked as AB from June 16, 2019, and the no contact order of June 19, 2019, pre-marked as AC, which once the jury comes back in, he will enter into evidence and produce them to the jury for their viewing. Are there any witnesses that you wanted to call that your attorney failed to call?
No.
Is there any evidence that you wanted your attorney to present that any of them failed to present?
No.
Are you satisfied with all of your attorneys up and until this point?
Very.
Is there anything that you would like to bring to my attention at this time?
No, Your Honor.
Okay, all right. I did receive the proposed jury instructions this morning. I'll look at them during the lunch hour, and after the state concludes their rebuttal case, we can proceed with addressing those. Mr. Beck, yes, sir.
No, the defense did not receive the red line copies that the court discussed yesterday. I don't know if those were sent or not.
I emailed Ms. Barrios last night. Once we got out of court, I'll send them to everyone this morning. Just give me a moment and I'll get those out right now. Is there anyone else? The email correspondence that I have is Mr. Owens' email, Ms. Andrews' email, Mr. Cacciatore's email. Is there anyone else that may need to be sent to from the defense side?
We'll pass them around.
Okay, all right, very good. All right, let's stand and bring in our panel, please.
Hey, Judge, I would like to publish these to the jury and allow them to take their time and pass these down to.
You may proceed.
I love that he calls the.
Defense exhibit 9.
I love that the judge calls the jury the panel, because it's like, are they? It's just, there's so many strange things that courts do, and I've never heard a judge call the jury a panel, but it is a panel of jurors, and I just love that. I don't know, it's just something that I love.
19, we'll just review it and pass it down. Next document.
I'm just scooting through this just to see what's happening. Where are we? What are we doing?
Defense or state, are you intending on putting on a rebuttal case?
Yes, Your Honor.
You may proceed, sir.
Faithful Dr. Tanya Warner.
Okay, so it's time for rebuttal case. So the defense is rested. They handed the jury the two separate incidences from the court documents of a no contact between her and Jorge. So that was the last thing that the defense did. And now it is time for the prosecution to have their rebuttal case. So they're bringing on more witnesses. They said there was going to be a lot of body cam. Now, if there's a lot of body cam, like if we're just going to sit and watch like the body cam again, we will sort of boot, scoot, and boogie through that, because we already watched the body cam in the beginning of the trial. But we will see. Maybe it's something different. Maybe it has a different effect. But I don't think, I mean, at this point in the trial, I just think that it's enough. We've been through enough. But their job is to make sure that it's more than enough. We're just like people who are just like, she did it.
The troops of Rebuttal, I do.
Doctor, good morning. Can you state and spell your name for the record for us?
My name is Tonya, Tonia, W-E-R-N-E-R.
Thank you. You may be seated, ma'am.
Thank you.
Good morning, ma'am.
Good morning.
Where do you work?
I'm employed at Meridian Behavioral Health Care in Gainesville, Florida.
And what services do you render there?
I'm their chief medical officer.
And can you tell the jury what your educational background is?
Yes. So I graduated with an undergraduate degree at the University of South Florida in chemistry. I then attended medical school at American University of the Caribbean. I did a residency in psychiatry at Connecticut Valley Hospital in Connecticut under the auspices of Yale University. I then came back to Florida and did a fellowship 1 year in forensic psychiatry at the University of Florida.
And since your educational background, what have you been doing professionally?
Yes. So I'm a licensed physician in Florida. I am board certified in general psychiatry and forensic psychiatry. I was initially employed on faculty at the University of Florida from 1998 through 2015. I retired there as the vice chairman of the Department of Psychiatry and the director of the Forensic Institute. I then went to work as the chief medical officer at Meridian Behavioral Health Care, which is a community mental health center.
Psychiatry?
So psychiatry is the treatment of mental health disorders.
And what is forensic psychiatry?
Forensic psychiatry is the interplay of psychiatry and the law. So anywhere where psychiatry intersects with legal issues.
What is the difference, if any, between a psychiatrist and a psychologist?
So a psychiatrist has gone to medical school where a psychologist has not.
And as a licensed physician, are you able to prescribe medication?
Yes, I am.
In the course of practicing medicine as a psychiatrist, do psychiatrists prescribe medication to treat mental disorders?
Yes, we do.
And when did you begin your work as a forensic psychiatrist as opposed to working at the faculty at the University of Florida, or was that concurrent?
In 1996 in the state of Connecticut. While I was doing my training at Yale University, I testified for the first time as an expert witness in the state of Connecticut.
And over the course of your career, have you done forensic psychiatric evaluations?
I have.
Approximately how many?
Thousands of times.
And does this include on matters such as competence?
Yes, it does.
And does it, just explain briefly to the jury, what does that mean, legal competence?
So competence is, do they understand the legal process? Do they understand who the different players are in the courtroom, who's on their side, who's not on their side, what they're charged with, what the possible penalties are, what the possible plea options are.
And have you ever done any forensic evaluations about insanity?
I have. I've done sanity at the time of the crime, and also I've been appointed by the governor of the state of Florida to do sanity for execution.
And have you ever been involved in working as a forensic psychiatrist involving the subject matter of battered spouse syndrome?
I have.
Can you describe your experience in that area for the jury?
I've been asked to do evaluations by the prosecution and defense several times with regards to, and it's come up in different cases, criminal cases with regards to intimate partner violence.
And does all violent episodes within a relationship result in something that we are describing as battered spouse syndrome?
No.
And I see there is a book in front of you. What book is in front of you?
Yes, so this is the Diagnostic Statistical Manual, and this is the 5th edition text revision, which is the most current edition.
Is battered spouse syndrome in there as a diagnosis?
No, it is not.
And where, if anywhere, does it fit into any of the categories within the DSM-5 TR?
It would come under one of the trauma categories, most specifically under most likely post-traumatic stress disorder.
Can you describe for the jury what post-traumatic stress disorder is?
So this is a disorder that's recognized under the DSM for individuals who have suffered a traumatic event, and then they have re-experiencing of the traumatic event. They have different symptoms besides re-experiencing, such as hyperarousal, and also avoidance of triggers or symptoms, things that would trigger a response to it.
Are there any agreed upon criteria within the relevant forensic psychiatric and forensic psychological communities about battered spouse syndrome?
There are.
And what would those be?
So it's again, having experienced a trauma, repeatedly, violence within an intimate relationship, and then having symptoms secondary to that, avoidance, so tiptoeing around, trying to avoid recreating the violence.
And if a person experiences an environmental stimuli, something happens to them, another person does or says something to them, is their subjective reaction what is defined as whether there's trauma present or not?
I'm not sure I understand the question.
Let me rephrase it.
You can rephrase.
Calls.
You described there's a difference between experiencing a violent relationship and whether or not that person is going to experience trauma from those behaviors they witness and experience. Is that fair?
Yes.
Now I've lost my train of thought. Is it fair to say that an experience that a person has, whether or not that person believes it's traumatic, is a subjective experience?
Yes, each individual is different, and so each individual is going to take that experience differently.
Can hypothetically a couple be involved in a violent relationship for a number of years, even 3.5 years, and battered spouse?
What is this symbol on her necklace? I love it. Can we see it? Can I, I don't think I can
Syndrome, not necessarily.
I can't like zoom in on the necklace. Oh, can we get better quality out of that? Because we can't get better quality out of when did you focus on games, so I'm dropping mine Discord. Well, we're watching a trial. I don't do Discord, unfortunately. I'm not I'm not into the whole Discord of life, but if I get a chance, I'll check it out. Thank you so much. Appreciate it. Lily Jack. Lily's a good name. So let's see. It's a cross inside of a horseshoe. Oh, what? That makes sense. It does look like a cross inside of a horseshoe. Do you think, wow, that's interesting. I like it. I like it a lot. I just wanted to take a moment for that because I just think it's really
Necessarily
cool.
apply to either
Also,
or both of them.
Is it?
Yes, that's
like a
correct.
diamond?
Can you explain that?
It looks like it's
So again, each individual is different. So one individual may develop the symptoms of battered spouse syndrome, and one individual may not under the same exact circumstances, just depending on their makeup and what they've experienced in their background and their biological makeup.
And is there a cycle of violence that's sometimes used to describe battered spouse syndrome?
There is.
Can you describe that?
There is. So there's the initial there's kind of a tension buildup section where you feel the kind of tension building up, and the individual can feel kind of the incident coming, and then there's the actual incident of violence. And then following the incident of violence, there's a honeymoon phase, what they call the honeymoon phase. And that's the third phase, where the individual who created the violence attempts to make up to the victim and recreate kind of the relationship and pull them back in. And then it starts all over again, where you feel the kind of tension start building up again to the incidents of violence.
Does abuse have to come in the form of physical or sexual violence?
No.
Can you explain your answer?
So it can also come in ways of coercion. It can come in ways of control, such as financial. So if an individual controls another individual financially, or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work, so controls their ability to make money or access the funds, so they can control them in any number of ways.
Is this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the receiving end of emotional or physical or sexual trauma and potentially experience, strike that. Can a man be on the receiving end of verbal, harsh words, physical violence, or sexual violence, and end up having the syndrome of battered spouse syndrome?
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
And can this element of control come from controlling personal items such as identification papers?
Yes, absolutely.
Can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's because he or she paid for it, even though it was a gift?
Yes.
And in this particular case, were you asked to do an evaluation of Sarah Boone?
Yes,
Do you see Ms. Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's sitting at a table there, wearing a dark suit and a pinkish top.
Did the record reflect she's identified the defendant?
Record will so reflect.
What date did you have an evaluation of Ms. Boone?
It was early in October, I believe October 2nd.
And this was at the request of the state of Florida
Yes, it was.
and subject to a court order?
Yes.
And who was present for this evaluation?
The defense and the prosecution.
All right. Tell us about the evaluation with Ms. Boone. What do you do first?
So I met with Ms. Boone at the jail in a conference room. Again, the prosecution was there and her attorney. I met with her for approximately 2.5 hours, just under 2.5 hours. I introduced myself and explained that the interview would not be confidential, that I would be coming to court if asked to share my opinions. And she agreed to participate. I then start out with just general information, so getting to know her, date of birth, kind of background information, who her parents are, childhood. I go through her educational background, work background, her marital background. I go through health, psychiatric background, any substance use issues. I do a mental status examination.
Can I stop you there?
Yeah.
Elaborate further on that.
So a mental status examination is just questions to determine kind of memory and cognition, kind of how their thought process is, how they're thinking. Are they able to kind of fluidly think through processes?
All right, go on after that.
And then I transition from there into walking through the incident that happened with her.
All right, what did she indicate occurred on February 23rd, 2020 to you.
All right, is it all right if I refer to my notes just to make?
Just, if you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she had a difficult time recalling what time they actually woke up that day. Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink, but that she asked that they could clean the house first instead, and that they did some vacuuming.
She said, "Can I refresh my memory?" And he was weary to be like, "Yes. Please don't read directly from your notes." She was like, "I don't even need to look at them, to be fair. I was just going to double, triple, quadruple check that I had all my information straight. But I'll just go off of my double, quadruple check that my memory of this whole situation is great." She is like, so there's a massive difference between psychologists, who we heard a bunch from yesterday, last day of trial, and psychiatrists, who are, they do different things. They have different educational backgrounds. Psychiatrists go to a full medical school situation. So they go to medical school. Psychologists do not. Psychiatrists can prescribe medications. So if you're going to see a therapist and they say, "Oh, I'm going to prescribe you this medication," you are seeing a psychiatrist. If you are going to a therapist and they say, "Well, I think that, you have this, and this diagnoses," I'm going to refer you to someone who can maybe share those same opinions, and we can get you on a prescription if you would like, but they would have to prescribe it to you. Psychologists will not prescribe you medication. They will refer you to a psychiatrist who they think would also have the same sort of finishing effect, like finishing thought, finishing diagnosis, and then point you in the right direction of what medication might suit you. Psychologists are going to work the brain, work your mentality, work your psyche, in a different way than psychiatrists do, because psychiatrists have the full education, the full educational background of the pros and cons of prescriptions. So, and there's nothing wrong with either one. I think they're both absolutely necessary and should be utilized to their full capacity. But if you are expecting to get a prescription out of your therapist and they don't do that, they're a psychologist. They're not going to get a prescription out of a psychologist. You have to go see a psychiatrist, who are definitely more expensive.
Vacuuming and cleaning. They had a half a bottle of wine left over from the day before that they drank. She felt about 4:00 in the afternoon. They drank that out on the back porch. And she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there a lot on the back porch, spent time out there. They did a puzzle.
Colloquially, sure. I can
out there. And completed that, and then did some kind of artwork. She felt like he was getting frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call them at that point, because they were already drinking. And she also at some point encouraged him to call his brother, because she wanted him to explain to his brother that he had pulled her down the stairs the night before, although that didn't happen. He didn't explain that to the brother, and according to her. And then at some point they went and got another bottle of wine and some cigarettes from the grocery store and continued to drink. And then they were inside the house, And then he, I guess, tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek. And she said she went upstairs and hid in the shower and waited.
Which is odd. If someone says tag, you're it, aren't you then playing tag? Okay, it's just, there are just so many things that just will never make sense to me. I am not a psychologist or a psychiatrist. Sarah Boone will never ever, there will never be a moment where I'm like, oh, everything that she has done makes sense. There will forever be moments of, I will never understand this person. If you are tagged, so if like I like, right, like if I come up to you, it's like tag, you're it. Are we playing tag, which is you tag each other back and forth, or are we playing hide and seek? Tag, you're it. Okay, I'm gonna count to. That doesn't seem. It's like if you were all sitting in a circle and someone tapped you on your head and said, "Goose," you then don't like go hide under the blanket. You're playing duck, duck, goose, and they're chasing you. Like you have to continue to run until you're being tagged. I am so confused. I am so confused. Not by the psychiatrist. She's great. I'm confused by how many lies, how many like I don't even want to say lies, just untruths. They're not, I don't think that Sarah Boone would consider them to be a lie, right? I don't think she would be like, "Oh, well, he tagged me and obviously that's like hide and seek." I just think it's a not truth, it's an untruth that she has just been so accustomed to say these odd things. Like it's just inside of her body to say these strange things. I don't think some of these things are malicious that she has done and she has said for sure. But I think that's just her personality type, her I don't want to say broken brain, but her a very, very, very atypical like chemical makeup that she just says things that are not true, even if it doesn't need to be not true. It doesn't make sense because she's not telling the truth. Why she thought this would be better than the 15-year deal is beyond delusional. Oh yes. Oh yes. Oh yes. That's like, and Sarah Boone had many opportunities to not do this, to not have her entire life broken down in front of the world. We're watching this late, but just this trial alone, thousands, millions of people are saying this woman is crazy. Like there's so many people that are saying that. I would say all of them minus one more than the people that know her, right? So there's like two people in her life that are like, oh my God, she's absolutely bonkers. But now there's millions of people that are like, wow, she's absolutely bonkers. And she could have avoided this completely. She could have avoided this completely, but she is so tenaciously delusional, delusionally tenacious, that she just could not go on her way without it either all going very, very well or all going very, very, very bad for her. And there's no in between. Somehow, some way, she could have found lawyers that are like, you guys, how dare you? How dare you make it seem that this tiny little woman who just had a couple of glasses of wine could do this to this strong man of full of anger and spite and full of drugs and at his last, pulling the last straw of his life because he's broke and has no job and can't hold a job. Like there was that could have happened. That could have happened. I mean, there's probably only one lawyer in like the world who would have been able to turn it around like that. But what is happening is the worst of the worst. And she sat on her high horse, just hoping and praying and kind of like a lot of us did during the election, we're like surrounding ourselves with the idea that it's going to go one way, and we're settled, we finally kind of find some comfort, and then it goes another way, and it's like, but what do you mean? All the things around me pointed north, and now we're headed south. But for her, it's not people that are around her agreeing with her, it's just her. And herself is so big to her that it can fill a room. So it's wild. She didn't hire Ellen Jackson. Yeah, she wanted this. She wanted this. She asked for this. She shook hands with it. She said, I'm ready for it. She said, I'm cool with it. And this is now it. This is it. This is it. And I know the jury sitting there like, why are we still doing this? Why are we still here in this? Can you just tell us to judge now? Can we now be judge and be done with this? I would like to go home. There's a juror that started this day out and who was like, I can't be here past 5:30. And literally all the lawyers were like, is that an alternate? Because if that's an alternate, we're like, just be done. Wrap it up. I mean, there's been a lot of things like the Karen Reed case. I want to get more information. I want more. Give me more, because every witness gave us so many more questions than we started that witness with. So we're like, okay, we have 10 questions. Like, where'd the glass go? Where'd the taillight go? Where's the footage? Where's her Wi-Fi stuff? And then we get a witness and we're like, okay, so where's the actual footage? Why was it flipped? Can we fire this many people? Why are you looking for nudes? What nudes did you find? If you were looking for nudes, you don't have it's like, I have so many, you just continue to have questions. I have no questions here. I just have confusion for an individual. I have no questions. So jury hasn't seen half of it. I know. And this is the worst part. This is the worst part, because the jury has seen such a small bit of what Sarah Boone is, and I can already feel what the jury, like I vibe with the jury, and they have no idea what type of menace she actually is, but for the jury, the prosecution has proven just how much of a menace she is in such a little small segment of her life. And then for us who have sort of followed and read and watched all the things of her going through lawyer after lawyer after lawyer after lawyer and writing all her papers and wanted posters and this, she's a menace. She's a menace.
Did for him to come, and he never came upstairs. Excuse me. And
get her some water.
So she eventually came out of the shower to look for him. And as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it. And sorry. And
get her water. Doll, are you okay? I got the text to be like, can you come in? And I have dogs, so I have to be like back to them every 3 hours. So I couldn't come in. Are you okay? Are you good? What is happening? What's going on? You poor thing. LMAO, the poster, Mr. Owens is a saint for taking this on. Yes. Why are they both hiding? Why are they both hiding? It doesn't, and like we can definitely go on, like I could continue to go on these tangents for all these little things that just will never make sense for Sarah Boone, but it's like, why? I'm better than earlier. I got food poisoning from the Wilton KFC and have practically been up since. No, doll face. Stop. That KFC has been on fire so many times. Oh my gosh. I can't believe anything would practically be undercooked enough to give you a sickness. I'm so sorry. Please stay hydrated. Do you want me to DoorDash you some Gatorade or anything? What do you need? I'm so sorry. This is literally the worst. A food poisoning is like so because you don't know when it's gonna begin. You don't know when it's gonna end. You don't know, like, are you gonna pass out? Are you hydrated enough? Do you want to keep drinking? If you try to eat anything, it's okay, good. It's all good. We have a bunch here. Okay. Well, if you need anything, you let me know. Okay. Oh my gosh. I don't have my car. I didn't because I can walk to my dogs. They're like a block away. So like I was like, I don't have the cars. But if you need anything, let me know. I can make some phone calls. I'm more worried about Ian. His actually was run. No, what? How much of it did he eat? And also, do you have pictures? Can we call the KFC? Can we call corporate? Call corporate. Get your money back at least. That's crazy. No, no good. No good. No good.
And so she went downstairs and indicated that she had found him, and they were kind of laughing. And she zipped the suitcase up, and they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. So, and she said she remembered what it felt like when he was choking her, and she became angry.
What did she do after she became angry?
I'm going to refer to my notes at this point.
So the last psychologist told us that she became angry. Excuse me, I just had breakfast and I'm like trying to get some coffee, and so I wake up. The last psychologist said she became angry because he became angry. She was angry. So he was in the suitcase, hee ha ha hoo hoo ha. We're having a good, funny, goofy time. And then he becomes angry. And in turn, Sarah Boone, who's not zipped up in a suitcase, becomes angry because she has all right to be angry in this very moment. Which is me not judging on their past because I know nothing of what happens behind doors. But I do know that she recorded videos laughing, teasing, taunting this man in a suitcase. So she became angry because he got mad. I don't like that. If someone is mad at you, they get angry, and you then get angry, there is no progress to be made in that situation. You are not allowed. Let me just say, this is not a forever, an always situation. You're not allowed to be angry because someone else is mad. If you become angry because someone else is mad, it is showing the lack of mental development, emotional development in you. If someone else is angry due to their own lack of emotional and mental development, that's another thing. But it is always going to be beneficial for you if you take the higher ground and recognize their anger, right? And recognize their anger, and you don't get angry. You be smarter than angry, because you know what happens when you become angry? You get really dumb. Like, you get really dumb. You do the dumbest things when you are angry. You get dumb. You don't talk right. You don't act right. You do crazy, stupid things. You drive fast. You drive really slow. You start swerving. You pull up your phone. Like, you do really dumb things when you're angry. Look at road rage. Look at road rage. People have driven cars off of cliffs because they weren't going fast enough in front of them or whatever, you know? People do dumb things when they get angry. Stay smart and don't get angry because they're angry. If there's a reason for you to be angry, then that's a totally different thing. But just because someone is angry, you don't also be angry. If there's other reasons, that's fine. But you know what I'm saying? Being angry because someone else is angry doesn't make sense.
To refresh your memory, just
I believe that she became angry, but it just doesn't make sense.
go down and then tell us what you remember.
If a man really hated ads, here's what he would do. Day one, he would install Pi on his computer without.
I don't know why this is happening.
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out and her son's baseball bat was sitting there and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
All right. Alcohol. Can you tell us what you know about the effects as a medical doctor of ethanol or alcohol on a human body?
Yes. So it causes intoxication, as we all know, and it causes disinhibition. It works on the frontal lobe of the brain and allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice, have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder. So we used to use alcohol dependence and alcohol abuse. It's now been combined in the DSM-5. In the DSM-5 TR, it's alcohol use disorder.
In considering what a patient or a client or somebody that you've been asked to evaluate by a government entity, do you take into account that person who's relaying the history to use a consumption of alcohol at the time of the history that they're given?
Yes.
Why is that?
Because again, it affects their behavior and their actions.
Does alcohol have any effect on a person's memory?
It can.
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication and battered spouse syndrome?
Again, it can affect your memory. It can affect your reactions. It can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse syndrome?
It would depend on each individual again.
Generally speaking, it is important as an evaluator to get as much information as possible before rendering an opinion, such as diagnosing somebody with something out of the DSM-5 TR or battered spouse syndrome.
Yes.
In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about...
Yes.
Okay, I want to know how many times she spoke to her. I think that's a fair question. How long did you spend with Sarah Boone? How many times? Because we heard the other psychologist met up with her 9 times over 8 days. They called a morning and afternoon session, 2 different sessions. So 9 times over 8 days. How many times did this psychiatrist meet with Sarah Boone? Which one do you agree with when it comes to, does she suffer from PTSD? Some sort of event or an accumulation of events in her past that has created some sort of traumatic disorder inside of her? Or do you think she did not? Which one do you agree with the psychologist? Or do you agree with the psychiatrist who's sitting on stand right now saying that she ain't got no PTSD, she ain't got no battered person syndrome, she's just an alcoholic? You let me know as we skedaddle through this. Oh boy. Oh my gosh. You're gonna bring the jury out. Oh no. Oh boy. Oh boy.
Hadn't had time to fully formulate that.
Okay. They're going to bring the jury out.
Figure out what we're going to do next. So I appreciate your patience. We're going to excuse you to the deliberation room at this time. Please do not conduct any independent investigation or research as the person, places, things, or charge involved, and do not have any conversations amongst yourselves or anyone else about those things, and we'll bring you back in as promptly as possible. Thank you.
He stays hydrated. Judge Cranick stays hydrated. Yeah, so they did a sidebar, and they mute all the mics at the sidebar, and apparently it took a little bit longer, and now the jury is heading out for them to, I guess, talk about how they're going to approach these next couple of questions, because it ended on that the psychiatrist says that she did not diagnose Sarah Boone with post-traumatic stress disorder, that she didn't have any markers or indications of PTSD, which would in turn be like a battered person syndrome situation. And the defense was like, whoa, hold on. He has so much PTSD. So I think they need more time to chit chat about
Sure.
it.
If you can find me that portion of the transcript that we were addressing as to additional opinions and other depositions and anything in Dr. Warner's deposition that you believe we need to address regarding this opinion as it relates to PTSD.
Well, Judge, it applied.
Okay. So she on the stand said, no PTSD. No PTSD. For sure. She ain't got it. But apparently the defense thinks that there's something or some reasoning or something that she said in depositions that would point to otherwise. But I know. So his little I love it so much. his little shadows. Sometimes he's got two people. I think there was a day that he had like 3 or 4 people behind him. They're like students who are like participating in like mock trials stuff or whatever. Like he's like an educator in the community as well. And so he has like these different students sitting behind him, and I'm just so jealous. I'm just so jealous because that would be so fun to be like, oh my gosh, yeah, no, and I got to shadow Judge Cranick on day 5 of the Sarah Boone trial. Like, that would be so cool. So let's hear what the defense has to say about Mrs. Warren. I don't know if she's married or not, about the psychiatrist who is saying she ain't got PTSD.
To every opinion she was going to express. It started on page 37, line 24. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder, and that she was not for sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. Mm-hmm. And then she also mentioned in that same answer that Sarah Boone had some narcissistic personality traits, and that those were my 2 major diagnoses. And then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder, and that I hadn't had time to fully formulate that opinion. Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38?
38, line 21. I need time to go through my notes, think about it, process it. But I had other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I have not had time to process on my notes.
Okay, so this was a deposition, not done yesterday, not done this morning, not done 2 days ago. She needed more time to go through her notes. She went through her notes, and Sarah ain't got PTSD. Like,
and I said on line 39, well, doctor, I'm trying not to inconvenience you. You know, we're set for trial October 7th for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, Mr. J asked, what's your position? He said, conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position. If she needs to issue a supplemental report, or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once jury is sworn and jeopardy attaches. And I say on line 23 at page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, but if that happens, I can bring that forward. And then you can add to your deposition at that point if my opinions change after having reviewed further. Now I refer to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
At Harbor Freight, we do business differently from the other guys. We design.
Be amended. Then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Then I respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that Mr. J upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens, I agree. And Dr. Warner, just let the state attorney know.
Okay, but we're skipping a massive portion of 41
Okay.
that addresses specifically opinions
Let me go back.
as it relates to generalized anxiety disorder.
Okay, the witness starts on line 15. So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more. Because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the Dr. Werner was considering that admission. But she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge, to being in the correctional setting right now. And that the stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to pose her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree. And Dr. Warner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it. Line 7, the witness, Dr. Warner says absolutely. And then, do you want me to continue reading or?
If there's portions you want to highlight for me, I mean, I have the transcript. I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that she may have. And so she starts talking about the mental status exam that she gave her, and then she page 43, line A, she said narcissistic.
Okay. So they have in the deposition that, hey, there's some things. But like any more things, I would need to think, I need to go over my notes and go over my notes and go over my notes and stuff. And so, yeah, but she's definitely got some narcissism. She's a little narcissistic, some tendencies, right? So the issue here is that in the deposition, she did not say, apparently, allegedly, that Sarah Boone does not have PTSD. That's not what she said. She did not say that she does not have PTSD. So that's the issue here. So the defense is going through the deposition line by line, and you heard Judge Kranick be like, whoa. If we're going to read it, let's not skip information. Let's not cherry pick information here. And even corrected him when he read it wrong, which is great. So this is, fighting for your client. Also, I would just like to note that my blanket that I like to use and is warm, because I don't keep my house very warm. I don't like that. But I do like to, throw a little blanket on, is currently underneath my cat, who apparently works about 80 hours a week. And this is the first time he's able to sleep because he looks like he looks very tired. And I just could never, I'm cold. I could never take that blanket out from underneath him. This is the first time he's been able to sleep in days, apparently.
She said she has narcissistic personality disorder traits. Or I asked that question. No, that's how she answered. She goes through a little bit of that.
Judge Kranick just like, and
then paraphrasing, she talks about the grandiose component or criteria that she met. And then on page 45, I asked her what other criteria, on line 1, would tend to indicate that she was a narcissist. And the answer, I didn't say that she was. I said that she has narcissistic traits. And that was the example.
Excuse me for interrupting, but can we lasso this back in?
I understand that's what the depo reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder. And at this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or a diagnosis of narcissism. The question pertains to PTSD.
All right, page 46. Line 1, question, okay. Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give any criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come to the jail and harm her. She talked about that. And she spoke about, having recollections, remembering abuse from George during the evaluation.
Okay. He just said that she didn't give me the criteria. So she didn't give me the criteria for that. So she doesn't have PTSD. I can't diagnose her with PTSD.
Question 13, line 13, on 46. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15, no. I would have to look back through my notes to see if she fully met the criteria. Question, line 17, can you explain why you don't think she suffers from post-traumatic stress disorder?
Why are we doing
Answer,
that?
line 19, no. I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question, is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? Line 24, answer, I may. Number 25, question, okay, and that's something you will let the lawyers know about if that changes? Answer, line 2 of page 47, yes. That's specific to the post-traumatic stress disorder.
Okay.
So at the time of this deposition, when I asked her specifically.
So what's the legal objection? What are the legal grounds of the objection?
I would not take that deposition, Judge. When she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that you had already told me it's not going to continue, I would refuse to take that deposition. But under the promises from the state,
What are the legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection?
What's in the box? This is giving you are at your final exam. This is giving final exam and like your professor is like, just translate this. And you're like, okay, great, awesome. So here's the thing. When we talk about all of the stuff that goes into translate, he's like, just translate this. What is the translation? And you're like, so you don't know. So you're fighting for your life. You're grasping at all of the straws that you see. And there's like one straw. And so you're just grasping at that. You do not have the answer. You cannot answer this question. He is not going to let this go. Judge Kranick understands, but you have to put on record the legal grounds for this objection, and he does not know it. They do not have one. Oh my gosh, this is kind of embarrassing.
I understand the backdrop.
I mean, I don't know if there's a legal ground other than we had an agreement as attorneys, as parties, that I would be notified of change of opinion and I would be allowed to take a second deposition. That's the only thing I know to object to, because I was not given that opportunity, which was an agreement between the parties.
Response.
For sure, hard
I
to
don't
watch.
appreciate the implications that they're making. What I would proffer with this witness is, we spoke yesterday.
Stop. Look at him coming up to the stand. He's like, no, there will be a microphone in front of my mouth, and I am going to be standing in between you and the judge as you're making these crazy statements. So, goodbye. Here's my butt. Judge, I'm speaking now.
I asked her if she had any change in her opinion about any of the diagnoses. She said no. And I asked, well, then my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing. And once he was already secured in the suitcase, she became angry and then did all the things that she did. My expected answers from the doctor, based on a very brief conversation yesterday and this morning, was that if I asked her whether or not PTSD or BSS had anything to do with this particular.
Hey. Oh.
Doesn't matter because of what she stated happened. I'm not asking her about her diagnosis of PTSD. I'm not going to be going into narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety, because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during the evaluation.
But the question was, and I may have to ask Madam Court Reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the evaluation.
Okay. Unfortunately, that was not the answer that came from the witness. The answer was a definitive no.
Attorney's.
I'm not casting blame. I'm just going back over of what was asked and what was said. Okay.
Yes. Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert. But that doesn't mean that that's my opinion, that post-traumatic stress does not apply.
That's irrelevant for the purposes of this argument.
Your discussions and him feeling like it didn't apply.
Okay, as an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed. And the opinion that was offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable. It doesn't matter because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time, Mr. Rose?
Well, to be fair, the question that he asked did not really prompt the answer. It doesn't matter. It does feel a little witness blamey. But to be fair, the way the question was phrased did not prompt for a response of it did not matter. It does not matter if she has or had or is going to ever have or will ever be diagnosed with PTSD. That was not the proper way to phrase that question to elicit that response. So let's move on.
The entire testimony of this witness, because opinions,
the damage is done.
Changed. I think I have a right to take a second deposition before she testifies.
What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
Mr. Crawford?
Yes.
All right, you've been present for all this hearing, yes, doctor?
Yes.
Am I misrepresenting any of our conversations?
No.
All right. And so if I asked you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening?
No.
That's it.
Judge, number one, she's given a legal opinion. Number two, it's a discovery violation.
What is the legal opinion?
The post-traumatic stress disorder doesn't apply in this case.
Dr. Harper testified it did, and that's what experts do.
Right.
I could have known that, and that was going to be her opinion before today.
That's not a change in testimony.
Where is that a change in
You
deposition?
have to read the whole transcript. I asked.
No. This is a 87-page transcript. You're objecting. You have the burden to establish your objection.
Give me a minute. I'll read through it and find where I asked her.
You've been had a minute. Okay. You've been had a minute. Okay. You should have assumed, in my opinion, I'm not a lawyer, but you should have assumed, this is my brain, you should have assumed as the defense attorney, the attorney defending Sarah Boone, that the prosecution would have the opposite of you. You should have assumed that the prosecution would then bring a psychiatric expert to the table to say that she does not have PTSD. That she is a little bit narcissistic. That she does not suffer from PTSD, that she does not suffer from battered spouse syndrome. She is just a flat out murderer. I feel like going in with that sort of mentality would have been good. Not fighting because you think that they are doing a little trickaroo on you, and then begging for more time. You do not have more time. You do not have any more time. There is no more time. There is no time. You have no time. The Judge Koenig, is not going through this deposition. Absolutely not. The problem in itself, the problem that started this whole thing, is the way the question was formed that elicited her to say she does not have PTSD. It was not a proper formed question to elicit, it does not matter if she has PTSD. The defense claiming some sort of illegal flipperoo, a little switch up, little whoa, little lie moment, is giving Sarah Boone. It's giving Boone, like it's giving the that's not verbatim what you said. Their expert witnesses said that she has PTSD. The prosecution's expert witness says that she does not have PTSD. Those two things are equal, and it is up to the jury to decide which one is telling the truth. We're having a very similar battle in the Karen Reed case. Everything goes back to Reed. All roads lead to Reed. Very similar battle in the Karen Reed case with experts. It is a battle of the experts. It is up to the jury to decide which one holds more weight, which one is actually right, and which one is actually experting as an expert. It's up to Karen, or it's not up to Karen. It's not up to Karen. She has no power. It's not up to Karen. It's up to the jury. It's up to the jury. Up to the jury. This is a fantastic moment, though, that we're seeing here. We're seeing the grasping of straws in a very desperate way, and I don't want to say it's sort of entertaining, but it's sort of entertaining. Oops.
I mean, this isn't the first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted, and the state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this, in her deposition when we had that hearing. So other than what's being provided to me right now, And what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which was the whole crux of the state's motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66, line 20.
This is so annoying.
Hang on. Yes, sir.
Page 66, line 20, question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer 23, no, sir. Not that I'm aware of. Line 24, question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1, yes, sir. Question. Then I go into these. Then on 67, line 7, question. Just double dog sure. You admit that you have no other opinions other than the ones you've expressed here today. Line 10, answer.
Just double dog sure. It is so wild to say at a deposition. Just double dog sure.
That I've been asked about. Other than 67, line 7, question. Just double dog sure. You admit that you have no other opinions other than the ones you've expressed here today. Line 10, answer. That I've been asked about. If I'm asked something else, that I'll offer it. Number 12, question. And you've been provided all the resources you need to rely on and express your opinions. Line 14, answer. I have based an opinion on the resources that I've been provided. If there's other things out there to be provided that may or may not change my opinion.
He's like, okay, and?
I believe it's a discovery violation because I should have been notified that there was going to be a change in opinions here today. And we had an agreement that I was going to be allowed to retake the deposition and not be ambushed in the middle of the trial with a new opinion.
What?
Ambushed? You think this is an ambush, my guy? Ambush is a little dramatic. That's a little dramatic. Ambush?
What new opinions are different based on what Mr. J proffered the testimony is going to be?
I have asked Madam Clerk to reread the question and the answer from the expert. It's been so long now.
Madam Clerk, or Madam Court Reporter, are you able to reread the portion of the proffer as to what Mr. J asked of the witness? Absolutely. Of course.
We don't get to see this very often. We don't get to see this very often where we see a direct rereading of what happened in court by the court reporter. It sometimes happens where it's like, could you just, can you repeat that question that I just asked? But it's been so long. We're like in a fight. There's no jury here. I love this. This is why we have a court reporter, for this very moment. Ugh, the sound.
Court's going to step off for a moment while Madam Court Reporter is able to provide that reading.
Okay, so I'm just gonna pause. So the court reporter, I guess it's a bit of a process to go that far back because they've been talking for so long and she's been getting all of it down. So she's got to go back. I don't know what technology she's using at all. But they go away and then they do come back. And let me get back to before they start talking again. Okay.
Hi, Mr. J, question. You've been present for all of this hearing, yes, doctor? Answer, yes. Question, am I misrepresenting any of our conversations? Answer, no. Question, all right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case and the defendant relayed them to you, what would be your answer? Question, that is not related to the incident that she reported it. Question, okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question, if you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
I don't think that's the very beginning, before I objected.
What was asked?
Unfortunately, she read the proffer. She didn't read the very last question before the jury was excused, before they had their sidebar. So they had a question and answer, and then they had a sidebar. They excused the jury, and then they had this whole back and forth, and then they had the proffer. So she has to go back just a little bit more.
We haven't had that read back. When it was first going on, when a question was asked, and I believe she rendered an opinion, and I, again, like that, we read back what the initial question was, what the response was, because it did, I know I objected, I can't even remember it now, but I know I objected because I knew it was inconsistent with.
You asked to approach, and then you explained.
Right. So you did not object when that question was read and answered. You did not object. You asked to approach. That is, oh God, Judge Kranick is so amazing. Like, you need to be specific. You asked to approach, you had a little conversation, and then you objected at sidebar. That's what, oh my God.
That the question was, it was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection. Now, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer? If BSS or PTSD has any, can you reread that? So
Let's just reread the entire proffer, just so that it's clear, soup to nuts, alpha to omega, what the proffer.
What? Wait a minute. Soup to nuts? What does soup to nuts mean? Wait, top to bottom, soup to nuts? Is that a thing? Did I wait? Okay, they're gonna reread the proffer again.
the proffer if BSS.
Was the back and forth between the prosecution and the witness as the jury is still not in the room. But the defense wanted to hear the question that the jury heard, that led to the witness saying that she does not have PTSD, which started this whole thing. But are we on board with soup to nuts? If that's actually what he said? Soup to nuts?
BSS
I
or
need
PTSD has
more.
any, can you reread that? So
Let's just reread the entire proffer, just so that it's clear, soup to nuts, alpha to the omega, what the proffer was. Madam Court Reporter.
Alpha to the omega. Soup to nuts? In my vocabulary forever.
If you could be so kind. Yes, ma'am.
Mr. J, question. You've been present for all of this hearing. Yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right. So if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Answer. That it's not related to the incident as she reported it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, does that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if you could go back to the initial.
Court doesn't matter. We are on the soup to nuts thing. What a cute little phrase. Honestly, it's adorable. So beginning to end, but how does nuts mean the end? Did nuts used to be considered dessert somehow? Yeah, I think so. I don't think I'd ever use that phrase again. Causes more confusion. Only if they are talking donuts. Dork. You're such a dork. It can mean greatest to least. I'm refusing to Google it because I assume actively Googling up. I'm already on to Alpha to Omega. So Alpha to Omega just simply is a colloquial term for beginning to end. It says used by Christians as a title for Jesus. The beginning and the end, the essence or most important features. So I don't know. So Alpha and Omega didn't really vibe that one, but so the AI Google response for soup to nuts from beginning to end. Soup to nuts is our air quotes. Soup to nuts is an American English idiom that conveys the meaning of from beginning to end, derived from the description of a full course dinner. Soup to nuts may also refer to Soup to Nuts, a 1930 feature film starring the trio who later became the Three Stooges. Soup to Nuts. A 1986 episode of Mama's Family. I don't know. So apparently Soup to Nuts could either be the Three Stooges before the Three Stooges became the Three Stooges, or beginning to end, because I guess nuts used to be the final course of a multi-course meal. We don't do that anymore. I don't know where places have courses anymore, we hear like main course, but they're really, we're not going out to Michelin star restaurants very often to just sort of grab an 8-course meal. But yeah, from soup to nuts, from A to Z, top to bottom. I love that. Soup to Nuts Urban Dictionary. Oh, but the Urban Dictionary is did you watch the State of the Union address last night? Soup to Nuts. Soup to Nuts, Urban Dictionary, a retaliatory action where scalding hot soup is thrown at the offender's junk. Wait, guys. Wait, soup to Dave, and here's like an example of its use. Dave accosted Jess for the last time and was threatened with soup to nuts. He'll learn this time. So we have to get back to court, because I feel like I'm just soup to nuts. I noted. Soup to nuts noted. Soup and nuts. I think that's something Sarah maybe came up with. Yeah, soup to nuts is wild. That's so funny. I've never heard Three Stooges. That's what it feels like, honestly. This got me distracted so bad. I went to McDonald's, not Jersey Mike's. Stop. You need to pay attention. You need to pay attention. Soup to nuts. All right. My feet are so cold. I have to go get blankets. I'm listening. I'll be right back. My heat is on too. Okay.
My understanding is it was the question and the answer right before Mr. Owens asked to approach.
Okay. Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her in jail.
Can you read that for me one more time, please?
The answer.
Both the question and the answer.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
We got the previous question one.
Question, and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer, I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change. Question, what was your opinion?
Strong.
Number one, that question and answer, she gave a different opinion than what she gave in her deposition, which, subject to the agreement we had, I should have noticed. Number two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end, some general, if you have any new opinions or anything new that differs from what you said here today, please notify the lawyers or words to that effect. So it's an evidentiary issue. I've got a right to be prepared for the trial through discovery to know what the witnesses are going to opine. And this is a discovery violation based on two things. One, her initial answer to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery violation. I asked that the witness be stricken.
Any response?
Oh, calm down.
The intent that I stated was the intent of my question, to get the answer that I intended to get was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm not convinced he understands what the answer means or what it's going to be. The answer isn't going to be Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case. Mm-hmm. What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That is not a discovery violation. Yeah. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 6.
I'm listening back to the question. They almost tricked me a little bit because I was like, wait, so she was like, oh, she doesn't have PTSD. Her response was not, she doesn't have PTSD. At the time, she was not as specific as she should have been. But also I just don't think the question was like, I don't think she was teed up properly. But to be fair, she did not say like she ain't got PTSD. So I don't know. I think that this was a little too much. He's trying hard. My internet's not happy. That's so annoying.
67 of the deposition, response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions other than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, then I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's not the story.
Any other argument?
The totality, if you read that deposition and all the
I specifically asked you, Ms. Rowans, to point out for me I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us.
Period.
If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them.
Well, the ones that
other than what you've already identified.
The ones that I expressed, and that just the understanding that we had that she, in the pages that I have talked about previously here today, the pages that I referred to about our agreement that she was going to let me know if there were any opinions that she had in addition to the opinions that she did.
He's mad at you.
Okay. All right, thank you. All right. Any other argument, Mr. J? Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, read back of the opinion that was previously offered. The portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense identifies that if there were any additional opinions, that there would be notification. So the court at this point in time as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369, Southern 3rd, 1243. At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
No, other than I understood she did give an opinion about post-traumatic stress in that initial series of questions.
Okay. All right, the court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial. Although the questions in the deposition as highlighted by the defense so far are do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back. Specifically, my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens. Because my question is, do you want it struck?
He's like, let me spell it out for you then. So we did see an issue. The judge saw an issue with the witness saying something that even though that was not spelled out in the deposition and made mention that if there are issues or changes or I feel differently, blah, 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 going through my notes, that it will be notified to both parties, you know, or to the prosecution, and the prosecution notifies the defense, what have you. So that's fair. Why is he doing this? I think to make sure that it does not come up during appeals. Judge Kranick has been so diligent and so patient and so mindful of every move that he makes, that giving possible fuel to any sort of appeals fires is not on his to-do list. So, giving the defense an opportunity to argue why the statement should be struck, or noted to the jury like, hey, ignore this question, ignore this response from this witness as we continue, I think is fantastic. It's hilarious to me that he has to spell it out to them. Ooh, exactly. The risk of trial number 2 for him is probably like he quits. He's like, I quit, you know, like, no, I'm not doing this again. I'm not doing this again. It has been years. And like, we are seeing a process of Karen Reed going to trial 2 years after the incident, and then on year 3 years after the incident, she has her second trial. This is the first trial 4 years after the incident. 4 years. 4 years she went to trial. It took 4 years for Sarah Boone to go to trial. He does not want to do this again. He does not want to do this again at all. At all. And that is so fair. That's so fair. Hello? Oh my gosh, he is so pissed about wasting time though.
So you do not want it to be struck, and you do not want a curative instruction.
Well, I'm going to question her about post-traumatic stress, so it's going to come out.
Yes or no?
Through my cross from the deposition about what she said, and then it's inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay, all right. Ms. Boone, have you been paying attention to the questions and answers and the read?
So the defense is no, don't strike it. Do not do a curative instruction for the jury about that statement. I want to impeach her. I want to make her look silly on the stand so that the jury does not take her seriously and takes their experts seriously and more serious and has more weight to them than this one. So, and I think that's a great move. I don't like this attorney. I don't like this team, but that I think is a very great move. The judge is annoyed because it's like, oh my God, whatever. I don't care. I don't care. Like, just do you, boo boo. But I think that's a fantastic move to say, no, I want to impeach her on the stand. I want to say she said one thing like this day and now she's saying another thing. Why has it changed? You know, why not lying? Why are you saying something different? So that's interesting.
You read backs of both the proffered testimony and the opinion testimony.
Yes.
And are you on board with the strategy not to seek to strike that opinion?
Yes.
Thank you. With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry.
With regard to the proffered opinions, the court will oversee a deposition now, and you may proceed.
Right now?
Yes. With regard to the proffered opinions.
You
And I
said
believe
right
that will
now?
provide a cure for the discovery violation under the Richardson violation based on your request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time. You may proceed.
Dr. Lloyd.
Yes, sir.
Good morning.
Good morning.
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussions since the phone conversation last night?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct. That my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed, that I didn't have enough information.
Okay. And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct. That was my opinion. Correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the incident to me.
Was that your opinion back when I took your deposition?
Yes,
When did you form that opinion?
when she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that, but you're saying you formed that opinion prior to the deposition, correct?
It's such a badass stance to be like, why didn't you tell me that? Like, he's just like, I didn't tell me that. She goes, I answer questions. I don't ask them. You didn't ask me, so I didn't answer because I was never asked. It's a deposition. You called me here. You subpoenaed me here. So ask me the questions that you want the answers to. Okay. So if you didn't ask me, I'm not going to answer because you got to ask.
Correct?
Yes. The state attorney and I discussed that on the way out of the jail, as a matter of fact.
After the deposition?
No, sir. After the evaluation.
Okay.
On the way out of the jail.
All right. And I asked you, were there any other opinions that you may express at trial after you had discussed that with the state attorney prior to the deposition? Is that correct?
Yes.
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be expressing in the Sarah Boone case.
He has said ambushed at least twice right now, and that is dramatic. Also, she's prosecution's witness. Yeah, of course. So she's very much like not for team blue. Like, she's team red. I don't know why I gave them colors, but like she's very much team prosecution, you can see this. She's annoyed that she's wasting her time here. She seems to be a busy person. She's got busyness. She's got things to do. I also just hate how many words it takes for them to ask these damn questions. Like, they say so many words. And it's like they start like 3 different times within one sentence. Like, just ask a question.
I didn't know what specific information you wanted, sir. That's why you had a deposition. I answered your questions. I don't know what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically?
No, sir, I answered all of your questions. And as I said, I'm happy to answer any questions that I'm asked. I don't know what questions you want me to answer.
But you know that this was a central issue in the case. Did you not? Your opinion
Yes.
is relating to a central issue in this case.
Correct.
You're aware Sarah Boone's on trial for murder.
That's
And you had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
Well, I told you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
That's not what you said.
Mr. J, anything else?
I'm just making sure you want to inquire,
This is your opportunity, Ms. Romans.
because that was more just about.
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and or post-traumatic stress disorder as proffered.
The problem is now, Judge, is I've got my expert, and we weren't aware. You know how in these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts. Dr. Warner, were you given the opportunity to read Dr. Harper's deposition?
I was.
I mean, that's standard operating procedure in these type cases, and now I'm taking a deposition on the fly, and then I haven't had a chance to speak with my expert about those opinions and whether or not that would change her opinion.
Why would
puts me in a
someone
very
else's
difficult
opinion
situation,
change
but
their opinion?
If I'm ordered to continue the deposition, I will.
That's your decision. It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Dr. Warner, you realize you're in a courtroom.
Yes, sir.
And we're waiting on the jury on the trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition, or you have not disclosed here today under oath?
I'm happy to answer any questions that I'm asked.
Are you refusing to answer my question about any other opinions that you intend to express here today as it relates to Sarah Boone, who was on trial for murder in the second degree?
But I'm going to check the catch-all vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not have. 99 out of 100 attorneys will come in here and say that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a question like that of an expert, the expert's always going to say, please ask me a specific question. And that's what she did then. That's what she's doing now. It's unfair and vague to ask somebody, tell me every opinion you have.
Judge.
Yes, sir.
We're in the middle of a trial. She's
Okay, yeah, exactly. We're in the middle of a trial. We're not even in the middle. We're at the end. We're at the end. We're in the rebuttal of a trial. We are at the end of a trial. Oh my God. This is wild. The jury is not here. The jury is not in the room for this. There is no jury. And I think it is 100% appropriate to say, I will answer your questions, but you need to ask me questions. And I think it's 100% appropriate for the prosecution to be like, ask her a question, you dumb. You can't just say, give me all of your opinions, because I got all of my opinions. All right, start with a haircut. Start with how your face is. Start with what you're wearing. Start with the shoes. I have opinions on everything. He didn't even narrow down opinions to her mental health status. She cannot just rattle off all of these opinions, because what do you mean? There was no outline. There was no basis. It'd be one thing if he said, hey, what is your opinion when it comes to her level of PTSD? Give her some narrowing down, but just to be like, what's your opinion on Sarah Boone? You know this is important. Yeah, of course she knows this is important. Yes, of course she knows this is a murder trial. She does mental health status reports on people who are about to be unalived by the government on death row. Okay? Like, she gets it. She's not going to just be like, oh yeah, by the way, I just also feel like this is going to be a thing. She's not going to risk her.
She's
This
fixing
is
to
hard.
testify.
This is
She's
hard
had
to watch.
conversations with the state attorney. She
But it's
knows what
very
she's going to be
entertaining.
asked in forms of opinions that she's going to express. That's why she's here, to help the jury understand the science that relates to the law and express opinions. I mean, for me to ask, we're playing hide the ball here? In the middle of a trial?
I disagree that there's any hiding of the ball. There's been a proffer that's been read multiple times.
Yes.
As to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant represented them. And the answer is they are not relatable to the incident as relayed by the defendant. That is the opinion that have been proffered.
All right, can I continue with my deposition?
Yes, sir.
Hello.
Do you recall expressing that you wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and she said no.
So a catch-all question.
Correct.
Were there any other personality
No.
disorders?
Oh, no.
in that what you
Oh, no. It is very different between you asking a catch-all question and her asking a catch-all question. This is a mental health evaluation that she was performing. You are a lawyer. You are a lawyer. You are a lawyer. Just because she asked at the end of her evaluation a catch-all question does not mean that the catch-all question was not answered within the communications, the conversations that she had with Sarah Boone. She was asking if there's anything else you need to tell me, because we've gone through so much and these boxes have not been ticked yet. So is there anything else you'd like to tell me? And then maybe whatever Sarah would say, if she had something to say, would have fit those boxes. But Sarah didn't say anything. Does Sarah and this person and the psychiatrist have the same rules and background? It's your job to ask questions. I'm getting so frustrated. How dare you? How dare you? That was so rude. That was so rude. And he's trying to get under her skin so that she looks and sounds really sassy when the jury comes back. I know he's trying to really just keep scraping at her, but I think she's too good for it. I think
As a
she's better than that.
psychiatrist, you diagnose an opinion, express opinions about whether people suffer from personality disorders.
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So, narcissism, you did not find.
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No, sir, I said narcissistic traits.
Okay. So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct. She displays narcissistic traits.
You express an opinion that she suffers from alcohol use syndrome.
Alcohol use disorder.
Alcohol use disorder. Is that still your opinion?
Yes, it is.
So she's a murdering drunk. Is her
Anxiety
opinion.
disorder. Is it your opinion she suffers from the anxiety disorder?
No.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you've changed that opinion now?
I have I'm leaning towards a adjustment disorder secondary to her legal situation.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
You agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with George Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
As reported by her. George can't make a report because he's been murdered. So they only have one side of the story, and that's not me saying don't believe all women. And I'm sure there are some reports, like police or hospital or what have you, which would continue to point them in the direction of a history of abuse. But to say, she said this, it has to be true with someone with a background of a lot of lies, it can unfortunately make it harder to believe.
In your opinion, does she suffer from any form of psychosis?
No.
Is it your opinion that Sarah Boone suffers from acute stress disorder?
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history to the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
She may meet the criteria for that.
May. So it's possible? Is that your opinion?
Yes.
Definitively, you can't say?
There's a history of her having that, yes.
So you agree she suffers from battered spouse syndrome?
Yeah.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
Any other arguments at this time?
No, Judge, just the one I've already made.
Okay, all right. The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert, as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
No, sir.
State anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can.
Before we bring the jury back in, may I approach Mr. Cacciatore with the related matter?
Does it need to be on the record or? Okay, go ahead.
We would concede that Detective Hopsel and Detective Lowen are not testifying against us. They've been here in court this morning.
They're still under defense subpoena.
Excuse me, I asked Mr. Henderson if you guys were calling Detective Hopsel again, and he said no.
And we're not. In our defense, our direct defense, is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to receive or seek rebuttal and possibly through these witnesses? They're under subpoena. And I'm sorry, Mr. Henderson's not here. I've just noticed their presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening to.
What's your base? Well, we're off the record. There's no jury here. That's fine. Y'all stay where you are. What's the basis for your sir rebuttal?
We don't know because I don't know what the state's going to place a rebuttal. But
it doesn't answer my question. What's the legal basis?
Oh my god. Okay, I'm being like sucked in. This is some of the most like actually like riveting moments of this case in my opinion, besides like the really traumatic evidence bits that we heard early on in this trial. So the defense is now wanting to argue, hoping to argue for a sir rebuttal, which is, so the prosecution puts on their case, the defense puts on their case, the prosecution gets a rebuttal. Typically, the defense does not in this court, and now they want one. Again, we're hearing a lot of words without actual legal basis. So when he's saying like legal basis, he's referring to when it comes to like objections. When judge is saying, what's your legal basis for this objection? He's expecting something like hearsay, asked and answered, argumentative. There's reasons why, like the legal reason, the definitive legal reason why something should be either had a sidebar about or objected upon. And there also goes in the same vein a legal reasoning why the defense should get a rebuttal, which is crazy. And his response was, well, because we don't know what's going on and there's some people that are still subpoenaed. Why are people still subpoenaed? And why are those who are subpoenaed in the court that are not expert witnesses is quite confusing to me. I don't think they are going to be handed the opportunity for a rebuttal because can we be done? We need to be done with this case. What more could you do? You had your opportunity. You needed to take full advantage of your opportunity of having your case in court. Like, you should have done all of it then. You should have ate and left no crumbs. You should have asked all of your questions. You should have called all of the people you wanted to call. And I honestly think it should have been down to just like 3 people because there was too much going on. There was too much going on. This poor jury, they're like, we all could have went to work today. We all could have went to work today because jurors don't get paid. If they do, it's like, I don't know, $4 a day. And they're all missing work.
So rebuttal.
Judicial discretion as to the fairness of the proceeding that the defendant pursued.
Okay. Anything else, Mr. Cacciatore?
No, Your Honor.
Okay. The rule of sequestration is still in full force and effect. Detectives Lowe and Capsule, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have give, and to comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much. Anything else, Mr. Owens, we need to address?
No.
Anything else, State?
No.
All right, let's bring back in our jury. You can continue your inquiry, sir.
To be fair, if you are not an expert and you are subpoenaed to be a witness in court, 99.99999% chance you are not allowed to be in that courtroom as the trial is happening. There is like a very super duper itsy bitsy slim chance that you might be able to be in that courtroom. But you should not hear the testimony of those before you. You should not hear the testimony of those after you. You should not hear any off-record conversations. You should not hear anything that's going on inside of that courtroom if you are testifying. I don't care who you are, unless you are an expert. Experts have that leniency as well to be in court and listen to the other testimony, to listen to other experts as well. Sometimes they want to be, sometimes they don't want to be. It's completely up to them. I have not really come across any trials where there was an issue with an expert being in court. So yeah, that's also weird. So if you are not an expert, which they were not, they should not have been there, even if they were excused.
Approach.
Okay, so the jury is back.
Be seated. Members of the jury, thank you again for your patience. We had some issues I had to address with counsel outside of your presence, and we're going to continue the
A lot of
State's rebuttal case this morning. Again, if you could please just raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach.
The defense. Okay, so now we're getting into some. Now we're getting into some energy that is a little, dare I say, mean girly. The defense did not request for the last response to be struck because that was an option that was on the table. The defense said, no, we'll just impeach. We'll just catch her out in the awkwardness and the lie so the jury can see that, she's been flip-floppy, wishy-washy. And the prosecution stands up, the jury comes back and says, strike last response is non-responsive.
Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that.
Wild.
Based on your evaluation of Ms. Boone.
Okay, so objection overruled. They didn't ask if the prosecution wanted the response struck. And that is, I guess, I'm going to say it's fair play. It seems a little dirty to me. They have other ways of getting to the point that they need to get to. That's crazy.
Ms. Boone and what she relayed to you about the facts of the case. Does PTSD or BSS have any relation?
Objection, that's an asked and answered.
Overruled.
No.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing when he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or there was an imminent risk of harm that she needed to protect herself.
Can we proceed?
Yes.
Oh, careful, ma'am. My cat has awoken from his slumber. I might be able to get my blanket. Hey. I might be able to be in possession of my blanket now. Let's just skedaddle through this. Wow, we're only 2.5 hours in. Oh my gosh, what is happening? This is almost, if I was a juror, I would be so mad that I was in court for over 3 hours. You show up a little early and you sat down and you heard questions for like 10
Please don't
minutes.
conduct any independent investigation or research on the person, places, thing, or charge involved, and don't have any conversations among yourselves or anyone else with regard to that, and we'll bring you back in as promptly as possible. Thank you.
Wow. The wasting of the jury's time is crazy.
Y'all can be seated. Thank you.
He doesn't seem like he's happy.
When you're ready.
What are we doing?
Yes, ma'am. Just go read it from the question, answer, question, objection. Let's just have we can buttress it.
I do.
Go ahead.
I do just have to like just continue to respect how Judge Kranick speaks to all of the faculty in the room. He's just so like it's just gentle, you know. Does a jury go to work in the middle of trial when court is not in session? Only if they're not sequestered. So that's a great question. So when so if they're say okay, great question. There is no like you cannot go to work rule when you are a juror. If you are a juror on a trial that is going to be in session Monday, Wednesday, Friday, you can go to work Tuesday, Thursday, Saturday, Sunday. If you work 6 hours at night from 8, what's that, 9, 10, 11, 12, 1, 2 to like 8 to 2, 8 to 3 in the morning, and you feel that you can get enough sleep between 2 and, you know, having to be in court at 8, you're not exhausting yourself, then you can go to work. If you work from home after court, you can go to work. It really kind of screws up a lot of people if they work a 9 to 5 Monday through Friday and court is 9 to 5 Monday through Friday. There is compensation for going to court, for being a juror. It is minuscule, if any. It's almost like embarrassingly tiny. You get paid to be a juror because bills need to be paid. If you are going to financially implode, if you are going to financially implode because you are on a jury, or you cannot miss not even one day of work, that question is asked during jury on jury questionnaires. So you will most likely be excused if you have a legitimate response of, I am not financially capable of missing potentially a week and a half, or 2 weeks of work. And the compensation from being a juror will not suffice. You will be excused. I don't know about you, but if someone zips me in a suitcase, I'm not laughing. I ain't laughing. And no, just the thought of that makes me scared. They're like, it's your civic duty. We'll pay you a few bucks because we're nice. Yeah. And it's like nothing. Like, it is so wild. Best case scenario, if you are not someone who like would love to be on a jury. Like, if you're someone who wouldn't love to be on a jury, you get called for jury duty, you get a day off of work, you go in, you sit down, you watch a video, and the case gets settled, you know, in the hallway, and you get paid your $20, and it's not even lunchtime. That's like the best case scenario. That has happened to me. I have been summoned for jury duty thrice. I think 3 times now. First time I called the night before like I was supposed to, and case was settled. Second time, no, first time was it the first time I got really excited. First time I got really excited, and I packed my little lunch, a little cheese, a little string cheese and crackers and yogurt, and I packed my little lunch because I'm like, I'm gonna be a juror. And this is going to be, I was like literally just freshly 18. I was really excited. We watched a video. They pulled out the AV cart. They put a VHS tape in. Golly, I'm dating myself. And we watched like a video of all these like 90s celebrities like LeVar Burton and like, I don't know, Sheryl Crow or something, and they're like, the legal process is really cool, and it's your civic duty to be a juror, and it's really fun, but don't tell anyone. And I was like, I'm so excited, and then they settled it, but we still got paid, but I still had to pay to park, and they did not validate my parking, which is So rude. But that's like that's the closest I've gotten to being on a jury. Sarah Lee, I'm sorry to continue to derail, but if you get jury duty and you act like you're too excited, does that get you dismissed sometimes? Sometimes. I just really am into justice, you know? I think they're definitely going to be like, why is she so happy to be here? Why are they so happy to be here? That's strange. I'm concerned. Yeah, I think if you're just pretty like even keel and you're not like super racist, and you're not like super sexist, then it's going to be a good baseline, because the prosecution and the defense both have say in who is on the jury, and they want a balanced jury, they want a fair jury, but they also want a jury that for both sides is going to lean their way. And so if you're just like not a terrible person, and you'll most likely be on the jury, especially as a woman. You want women on juries. You want women on juries. A lot of these juries, you sometimes see that they're a little heavy on the women, just because women can like speak just sort of like a generalized, not actually true, but like a stereotypical, women have a better ability of like speaking about emotions and the way they think, and but that's just a generalized stereotype that's not actually true. I think both men and women have a great ability to speak on emotions and sort of break things down and have those conversations. But yeah, I have seen a lot of times, like a lot of these big cases, it's like, oh, 8 women, 4 men, or 8 women, 6 men. It's a little heavier on women when it comes to juries. But that is just what I have seen. It may not be statistical truth. Let's see if we can, where we're going with this. We are only 2.5 hours in. I do have to skedaddle. Let's see, 11, 12, 1, 2, probably around 2:30. I'm gonna have to skedaddle. We'll have to stop and start a new stream after probably like an hour, just to check on some we can get.
All right. Irrespective of whether anybody has any opinion about whether Ms. Boone is suffering from PTSD or DSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD or DSS have any relation? Mr. All's objection passed. His answer, the court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek, they were having a good time, they were laughing when he got into the suitcase. When she found him, they were enjoying themselves. She zipped him, they were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk of harm.
Any other argument, Mr. Hans?
That invades the province of the jury. That's a decision whether or not she had imminent risk of harm or perceived an imminent threat. Is a question for the jury. This expert can express opinions on science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify. That you should rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
Response.
It's not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion upon the applicability of a particular set of evidence that testimony that the defense has offered, called battered spouse syndrome, to kind of help explain a portion of the justifiable use of deadly force or not deadly force instructions. She's not up there saying Ms. Boone was unjustified in doing what she did. She's not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Dr. Hargrove, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time, despite his mental illness, because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer, it's not becoming the juror, it's explaining a particular type of expert testimony, and it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply and that she was in constant fear, and the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony.
Any other argument, Mr. Owens?
That's totally wrong. He claims, the prosecutor claims, Dr. Harper came in and said BSS does apply. That's true. But he just got through saying and trying to get the witness to say BSS it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play. Post-traumatic stress disorder, Bader-Strauss syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about Bader-Strauss syndrome.
How does that have anything to do with whether or not it's an improper legal opinion under 90.703?
It is. It's the ultimate issue of fact in this case because self-defense has been alleged by the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for Bader-Strauss syndrome, under the jury instructions under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm at the time.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976, 7 seconds 660 at pinpoint 661. In that case, a psychologist testifies in the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion. See section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Overruled.
I was going to ask you to read the question and answer.
Oh my God.
Okay, thank you. He's going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
I object.
Basis. Overruled. There was a pending objection. I'm allowed the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to be at least an hour for mine.
We're going to begin your cross-examination after we're done with the state advises the jury in open court. If there are no more questions, let's go ahead and bring back in our panel.
What a nightmare of a day. Judge Kranick he's showing his frustrations are showing a little bit. His vocal energy has decreased. Yes, volume. His vocal energy has decreased substantially.
Or BSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD?
She's just rereading the question and answer that led us to having the jury leave yet again.
BSS have any relation? Mr. Owens' objection asked and answered. The court overruled. The witness, no. Question, in what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part of about playing hide and seek. They were having a good time. They were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him. They were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further questions.
Any cross-examination?
Yeah.
You may proceed, sir.
Okay, we're going to start with cross.
Good morning.
I have to go deal with my cat real fast, but I'll be listening.
Well, all did you
I don't-
consider collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview of the defendant. I had
That's the 2-hour interrogation with Detective Lowen and Detective Copson?
it was an interview, yes.
Excuse me?
Yeah.
Okay, go ahead.
It was labeled an interview. Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And then I had some cell phone records. And I also received the deposition of your expert.
The deposition of Dr. Julie Harper?
Yes.
Okay. And did you listen to Dr. Julie Harper's testimony in this trial of Sarah Boone?
No.
Do you agree you have a right to do that?
Yes.
And did you listen to Sarah Boone's testimony in the trial of this case?
No.
Do you agree you have a right to do that?
Yes.
And you elected not to listen to her testimony before expressing opinions here today?
Overruled.
I did not have time to do that.
You did not have time to do that?
Correct.
She's on trial for murder.
Yes.
Sustained.
You said you considered some text messages from Sarah Boone's phone.
I reviewed them, correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
Yes.
Regarding these text messages that you provided, did that inform your opinion that you just expressed about the inapplicability of BSS or PTSD to the facts of this case?
No.
Did it apply to your opinion that Sarah Boone suffers from battered spouse syndrome?
No.
Are that information, when you express opinions in court about a patient or about an individual, you rely on your personal assessment as well as the documents and evidence that you're provided and asked to review, are you not?
Correct.
And in this case, your testimony is that you reviewed all that information before you interviewed Sarah Boone for 2.5 hours on October the 2nd of 2024, 22 days ago.
Correct.
So you had the information,
Yes.
the documents, you read the documents,
Yes.
you read all the text messages,
Correct.
and you are going to express some opinions here today, are you not?
Correct.
You're going to express some opinions about narcissism, whether or not you had.
Yes. Objections overruled. You may proceed.
Thank you, Judge. Ma'am, is it fair to say, in your evaluation of Sarah Boone on October the 2nd of 2024, that you felt like the text messages that you received from the state attorney
Objection against scope.
Overruled.
are not relevant to your evaluation of Sarah Boone?
Withdraw.
I wasn't sure at the time who actually, I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure, I have no proof of who actually sent the text, who actually had possession of the phone and put the text, any of the text in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition.
The deposition.
By Zoom, yes.
You appear by Zoom, I appear by Zoom, the state attorney appeared by Zoom.
Yes.
And we discussed that these were the phone records from Sarah Boone's phone.
Yes.
Okay. And at that time, you said they're not necessarily overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
You may.
I have it. If you just refer me to the page.
Just a moment.
You got it?
I do.
Page 14. My question is at line 3. Your answer begins at line 5.
Correct.
And you agree that any,
Let him finish. Let him finish.
well, I'm going on, I'm going to ask another question about the text messages, Judge.
You just said line 5. Approach.
Dr. Warner, did that refresh your recollection about our discussions about the text messages in your evaluation?
Yes.
And would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone?
Correct.
And you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone?
Permission to go on here?
Can she answer the question?
Have her answer the question first.
I'm not sure what you're referring to in the deposition.
Page 14. My question is at line 21. Your answer is at line 25.
Correct. And I said no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is, there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations?
Correct.
And you agree your answer is no?
As I said, it made me aware. That's not my complete answer.
Okay, well, let's talk.
It made my
First, you said no.
As I said.
This is getting spicy. I, of course, needed to step away for a minute as things got a little tense. The prosecution is begging for a voir dire, which is question and answer time, Q&A with the witness without the jury present. Wow. Okie dokie. Okie dokie, folks. This is definitely not how today expected to go, which is the theme of this entire trial.
I said, it made me aware that they had a volatile relationship. It's not my complete answer.
I know, Dr. Warner, but didn't you say no to me? That was your first sentence, was no.
It's not my complete answer.
I understand. I'm going to let you answer that. But when I asked you
I'm gonna let
if
you
there was
finish.
anything in the text messages that caused you to pause and it would in some way affect the impact on your evaluation, your answer to me was no.
It's not my complete answer.
I understand. But was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
at the same time, Dr. Warner,
Oh my God.
Dr. Warner, at the same time,
Oh my gosh. Look at her looking at the jury. Like, are you recognizing that he's trying really hard, but it's not going to work? She's looking at the jury. She's like scanning the jury. Like, you see this? You see this, guys? Do you see this? Wow. And then he just tried to get her attention. Let me just go back. Oh my God. This is crazy.
I understand. But was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
Look at her scan.
at the same time, Dr. Warner, at the same time,
Hello,
you expressed
we're here.
that they had a volatile relationship.
To be fair, she has to listen to you. She doesn't need to make eye contact with you. She is on stand to be an expert. She is speaking to the jury. She does not need to make eye contact with you as you are asking her questions. That was very patronizing to be like, hello, over here. Hello? Hello?
That is not the totality of my answer either.
Okay, and I'm going to get to it.
Okay.
But part of your answer
But
was
you're
that they
not.
had a
But
volatile
you're not.
relationship.
Correct?
And this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship and that she text messaged calling him an idiot, a fucking idiot, for overdrafting her account.
Correct?
And in those text messages, there was some reference to domestic violence between the two.
Correct?
And that demonstrated to you that they had a violent relationship.
Correct?
And do you not agree that that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, we need to object. We need to approach.
We object and we need to approach. Wow. That is not. Oh, I thought they were back. Oh my
All right,
gosh.
members of the jury, it is 11:55. At this point in time, we're going to go ahead and take our lunch break. I'm going to give you a similar instruction that I've given you throughout the last couple of days. Give me a moment to pull it back up.
Whoa. Oh, wait, hold on.
At this point in time, we're going to go ahead. All right, members of the jury, it is 11:55.
He didn't say if it
At
was
this point in time, we're going to go ahead and
overruled
take
or
our lunch break. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer.
The jury is leaving.
Y'all may be seated. State, anything else?
No, Your Honor, thank you.
Defense? All right, we'll see you at 1:30. Thank you very much. Court's in recess.
Oh, wow. They take about an hour and a half for lunch. Court is in recess. I have probably like another half an hour that I could stay. So let's just start the second half. And then my plan is I got to go back to my pups. And I got to go play with them, of course. And I might just pick up the stream down there as well. Because if we get through, let's see, it'll probably only be, let's see, so they're hour 5, 6, 7, 8, 3.5, so it'll probably be close to like 3 hours maybe. I'm guessing. Okay, they're gonna get to stuff. I'm just kind of seeing what they get to. They're gonna get to some videos and stuff. They're gonna finish up here, so I will be here until about 2:30. I'm going to go down to my dogs. I'm going to play with them a little bit because they're so cute. I love them so much. And then we will pick up with day 5, part 2 stream, wherever I am, probably down there. So let's just see how far we can get into the second half of the day here.
The jury is sworn in jeopardy attaches. Line 23, Mr. Owens, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. The witness on line 4, page 40. But if that happens, I can bring that forward and then you can add to your deposition at that point. If my opinions change after having reviewed further. Line 8, Mr. Owens. Mr. J. Line 9, Mr. J. I think you need to plow ahead. This is our time whether the court reporter is prepared to give us a transcript by the end of the weekend. And if something needs to be amended, then she can A, issue a report. And then B, if you need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Line 23, page 40. Mr. Owens, I'm not suggesting that, Mr. J. I'm suggesting that we just said at the very beginning. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnoses or opinions. Then Mr. J goes, I think he gets confused about an issue relating to a diagnosis of an adjustment disorder or anxiety disorder.
I think he gets confused. I think everyone is confused.
So we get down to the bottom of page 41, line 22, Mr. J. Okay, so on this topic, if something new comes up, then we can address it. But if we have other topics to depose her on, then I would suggest to go on. And then page 42, line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot and formulate any other opinions, just let the state attorney know and we'll address it. Line 7, the witness, absolutely. That was our understanding. I've been ambushed by a new opinion that I was.
Third time that he has been ambushed with a new opinion. The third time he has been ambushed.
Not made aware of by any kind of report. I was not notified by Dr. Warner. I was not notified by the state attorney, William J. I first heard about the opinion when she testified to it, and I objected to it, relating to imminent threat, the ultimate issue of fact. I moved for a total dismissal for prosecutorial misconduct.
Denied. And here's the other.
He didn't even breathe. He didn't even take an absolute moment. He just said denied. Wow. Let's listen to that one more time.
And I objected to it, relating to imminent threat, the ultimate issue of fact. I moved for a total dismissal for prosecutorial misconduct.
Denied. And here's the other reason it's denied. Page 38 of the deposition, specifically that you made reference to, starts at page 21, line 21. The question preceding that is important. Question 14. So from my understanding, when you just said was, yeah, I agree with general anxiety disorder that she had been diagnosed with. Answer, no. I said it would be generalized anxiety disorder versus adjustment disorder, and that I hadn't had time to fully formulate that opinion out. This entire conversation pertains to those two issues, anxiety disorder and adjustment disorder. Has nothing to do with PTSD, nothing to do with battered spouse.
The judge, we go on, and I see what she's doing, that she's saying, hey, I got jammed up. I had a deposition yesterday. I didn't really have time between the evaluation and the deposition 2 days later. She had a deposition in between to really think about it, really review my notes. So as a catch-all, I said on page 40, if you have other opinions or other diagnoses after she has more time to think and review the paperwork, then obviously that creates an issue. So yes, that was initially what she was talking about specifically, but I realized what she was saying was she was going to have to reflect on a lot of these opinions. So that's
respectfully, sir, that's not what it says.
Just because you asked a catch-all does not mean that it's going to work. Well, you got anything else? Any other opinions? It doesn't work. It doesn't work.
That's specifically in line with the anxiety disorder versus adjustment disorder. That was the entire topic that was being conversed with. Now, later in the deposition, there are references, as I believe that I identified previously. Give me a moment. On page 59, line 22, question is asked, okay, and do you intend on expressing any other opinions other than what we've spoken about here today? Line 25, no. I will answer whatever questions I'm, moving to page 60, line 1, asked. Page 60, line 11. Well, let me just start with 2 because it gives it more context. Question, well, I'm asking now. I mean, you're the expert. I'm not. You're the one that's evaluated her. You're the one that's given her the test. I don't know the field like you do. You know the field. I understand you've said, hey, I want to think some more about, hey, I want to think about this some more. I want to review my notes some more to see if, but in terms of right now, without any further reflection, without any further answer, yes, sir, question, reading of the notes, any other opinions that you think you could express in any form or fashion with all this experience, almost 1,000 jury trial or 1,000 trials you've testified as an expert. Anything else that comes to mind that may be an opinion that you might express in Sarah Boone's case? Answer. Anything else that I'm asked with regard to her diagnosis come into play with regard to her case, I guess? Question. What other opinions do you believe you're qualified to express as it relates to Sarah Boone and the facts and circumstances relating to this case? Anything with regard to her diagnosis, I guess. 61. Of those 4 things we mentioned, line 2, correct.
And Judge, the 4 things were mentioned were related to the anxiety disorder, the narcissism, the battered spouse, the alcohol use disorder, which were in pages 58 and 59. But the overall thrust of that was any other opinions that were expressed. That was in good faith what we were doing. I would have, like I said before, I would have never taken her deposition. Once she said I hadn't finished my analysis and I may need additional information, just like he said the other day, Dr. Harper, if you get those additional medical records, Mr. Owens, about George Torres and give them to Dr. Harper, then I'm going to want to take her deposition again. The same rules apply. Why would I take her deposition when she hasn't finished?
Because the court ordered you to take her deposition because there were concerns about being able to have all of this done prior to trial. And you had concerns about what she was going to testify to. And the court set a scheduling order as to when, how, where, and the deadlines for those depositions to be conducted.
That prosecutor should have let me know if he was going to ambush me at trial. I should have known beforehand about a new opinion that Dr. Warner was going to express, especially related
4
to
times.
battered spouse, post-traumatic stress, and whether or not it was an imminent threat at the time of this event.
And the court's addressed that. The court did exactly what was required by binding precedent by the 6th District Court of Appeal and held a Richardson hearing, analyzed the 3 factors as required by Florida law with regard to those, and gave you the opportunity as a cure. Now, with regard to your request to strike or dismiss the case due to prosecutorial conduct, the case law by the 3rd District Court of Appeal filed April 10, 2024, State of Florida versus Denninghoff, Denninghoff, and I can provide you a citation momentarily, states that dismissal is an extreme sanction to be used with caution and only when a lesser sanction wouldn't achieve the desired result. Specifically, dismissal of an information or indictment is an action of such magnitude that resort to such sanctions should only be had when no viable alternative exists. There were multiple viable alternatives, including but not limited to my request, an inquiry of whether or not you wanted that struck, and the instruction to strike that opinion, which you demurred and said, no, I want it for cross-examination. And I gave you the opportunity twice to depose her here in open court, which I oversaw with regard to any opinion that she had based on the proffer or any other opinion that she would be offering today. For those reasons, the court is not going to exercise its discretion and strike due to the extreme nature of striking a criminal charge and for the adequate remedy that has been provided to you. Is there anything else, sir, we need to address?
May I supplement the record?
Yes, sir.
But this deposition did not end on page 40 or 41 or 42. Mr. Owens took a direct examination of this deponent for 68 pages, and then it was turned over to myself for cross-examination during the deposition. Beginning on page 75, I asked the deponent, what did the defendant say about the murder? What she said on page 78,
big time. And it's very interesting to see him fight this hard and use at least 4 times the word ambush because it really doesn't feel like this was an ambush in any way, shape, or form. It's not giving that at all. It's giving you stepped into a shit show. And now, you're covered in shit. But the show must go on, right? But the show must go on. It's giving. What do you're making a big thing out of a not so big thing, and I know that you're a lawyer, and I know that you feel that this might be a big thing. But in the grand scheme, and I'm not a lawyer, so I don't think about I don't really think about the effects that this would have on the appeals or quite possibly, returning for a trial due to a mistrial and all that things. I think about it sometimes, but this is a lot of wasted time for the jury. And I can tell, I can hear, I can feel which Judge Kranick talking and emoting and attempting to listen and be open-minded and try to be as patient as he always has been. He is pissed that the jury's time is being wasted. I sincerely hope that Mr. Owens feels he is trying to give Sarah the best possible defense for everyone's sake. I think that he is sort of lost in the lawyering sauce a little bit. Hopefully it's because he feels that he's doing it for Sarah. Hopefully that's like the basis, but I do feel that he's kind of getting a little lost in the sauce. That the words that he's picking, that he's cherry picking through this deposition are not the words that are actually there. And she said it, and I know a lot of witnesses are going to be on the stand, especially during cross-examination, and be like, yes, but that's not my full response. Yes, but more. Yes, but there's more. But wait, there's more. And that's, that's cross-examination's job, is to sort of call them out, and do that. That's their job. That's the attorney's job during cross, is to be like, you don't get to explain in this moment. These are yes or no's. I can ask you these questions and you answer them. Answer the question, not if I am going to give you time to give some full lengthy response. But at the same time, unfortunately, he was met with someone who was not going to lay down to it as a witness. She was not going to just be like, yep, that's what I said. That's what I said. She's going to make eye contact with every juror over there and say, you all see what's going on, right? Okay. Which is, it happens. It happens. And I don't think this was an ambush. Pulling at strings for sure. For sure.
Was that starting at line 13? And she said there was a suitcase and some clothes that had gotten out to donate, and they were trying to get that together. And it was on the floor in the living room. And that, as she was coming down the stairs, she saw him kind of slipping into the suitcase as a...
And I know I talked about this early on in the trial. The suitcase is downstairs because we're pulling stuff from the closet upstairs to donate. And we're donating the whole suitcase and everything. It just that never made sense to me. Like, your suitcase is upstairs. The stuff you want to put into the suitcase to donate is upstairs. So why did you take the suitcase downstairs to go through everything in the closet that is upstairs? That's like number one thing that does not make sense to me, but I digress.
As a hiding place. As she said, I saw him in the suitcase and I zipped him up and we were laughing. She said then he said he couldn't breathe, and I remembered feeling I couldn't breathe when he was choking me or sodomizing. And I was angry and I shook the suitcase. I lost control of the suitcase and it flipped. And she goes on and on about what happened. Defense counsel was there. He heard this testimony that there was no imminent danger presented at the time that she began getting angry, shaking the suitcase, hitting him with a bat, so on and so forth. And he didn't ask her that question after she had specifically instructed him, if you need an opinion of mine, you've got to ask me the question. It's unfair to experts to be thrown with this catch-all provision of, please tell me any opinion about this case that you may think is relevant. Well, what the doctor may think is relevant is different than perhaps what counsel thinks is relevant.
I can believe that. I heard in passing somewhere that there actually was a recent trip where it had been used. Who knows anymore? I can believe that because there were things inside the suitcase, like papers, and I think there was like receipts and stuff like that, and maybe like one fabric material or something like that. There were things inside the suitcase because there were things that were collected by evidence that were inside the suitcase when the evidence was collected. Then that things also had, like blood and bodily materials on them. So I can believe that. Who I'm expecting it to be sort of like, I'm assuming, this is an assumption, that they went on a trip and they got super annoyed, or they used it for something and they got super annoyed that the zipper was broken on the suitcase. And it's like, at this point, the suitcase is so old, we'll just get a new one. Like, let's just throw it out. We have so much other stuff to donate. Let's just get rid of it. Maybe someone can use a suitcase like this that doesn't have a working zipper, because it was known knowledge that the zipper did not work, because there was like a paper clip or something that was slipped into the zipper pull, like slipped in as like a makeshift zipper pull. So I can believe that is fully believable.
So it's really an unfair criticism of the state, and probably more likely self-reflective that this deposition, this opportunity to ask about this obvious issue did not occur. So That is what I would like to supplement the record with. The deposition was substantially longer than page 41 or 42, where it's acting like it's concluding and, is there anything else? The state would just submit, I understand very well what my ethical duties are. I do not have any ethical duty to provide him an unrecorded statement that is not inconsistent with prior testimony. This doctor did not give me any unrecorded statements inconsistent with her testimony. Thank you.
Thank you.
Judge, I'd like to add on page 79 that Dr. Warner claims that Sarah said he put his 2 fingers out and I hit them with a bat. So there was rule of completeness. But for him to say that that's not standard operating procedure when you're taking a deposition of an expert.
Mr. Owens,
he wants to talk.
Hold, sir.
Judge Koenig was like, you're going to interrupt me? I'm done.
I understand. I understand your position. However, the questions that were specifically asked, which gave rise to this, specifically pertain to opinions of PTSD. I'm not going to rehash any and all of those things. The record speaks for itself. The court has ruled. Your motion for dismissal of the charges is denied. For the record, the citation that the court relied upon with regard to Denninghoff is located at 388 Southern 3rd 10055, located at pinpoint 1057, Florida, 3rd District Court of Appeal, April 10th, 2024. With that, are we ready to bring back in our panel?
No, sir.
Okay.
Judge, I've got Earhart's Florida Evidence 2023 edition, volume 1, Charles W. Earhart.
Let me tell you how you're going to rule on this, sir. I'm going to allow you, as I said up here at sidebar, to go into the facts that she relied upon and what it is that she utilized. I'm going to allow you, sir, as I said up here at the bench before the lunch hour, to go into those opinions that she didn't offer here today. And on rebuttal, Mr. J, I'm not going to allow you to stand up and say, may I have what ire? That wasn't one of your opinions today. You can address all of that and redirect. Is that clear?
Clear to state.
Judge, let me just review to see if, because I had several.
He said, I have told y'all what to do, how to do it, when to do it, and why you're doing it this way. Why is there confusion? You bring this up to me. You bring me this case law as if it is going to change. Because guess what? It is not. I have ruled, and I will continue to rule in this way. I know the words you are about to say, and they are not going to work. Period. Point blank. Soup to nuts. Can we be done? Soup to nuts. Soup to nuts. Soup to nuts.
What you had inquired of me, Mr. Owens, up here, was that you wanted to go into these other facts, medical records, text messages, statements, and you said, if I can't do it now because he's going to object, I'm going to call her and assert rebuttal. And the problem, as the state pointed out, is that you can't use her as a conduit to admissible evidence on direct examination. And that if you want to do it, you got to do it now. And your argument was it goes to her bias, it goes to her credibility, and that you're permitted wide discretion on cross-examination. I agree with you. I agreed with you before the lunch hour. My ruling hasn't changed. I'm going to absolutely allow you to go into those things.
I appreciate that, Judge. The other thing I wanted to readdress.
He's like, you're still talking? He's like, you're still talking? Okay. Wow. Fantastic. I would learn things if Judge Koenig taught me things. I'm learning things. I'm actively learning things. And if I was to take a course, I would be like, I cannot wait to go to this class. I cannot wait to go get educated. There's just an air of professionalism. There's just an air of constantly, his brain does not stop. His processing does not stop. When we compare trials to Karen Reed, which we often do, Judge Beverly Cannoni compared to Judge Michael Koenig, there is a total 180 of active listening. We are getting immediate, before you even speak, I know what you are going, there's almost mind reading happening here, and it's fantastic. It's amazing. He wants to be done, obviously, with this. I don't blame him. But he's not going to let anything slip. Brilliant.
Yes, sir.
Judge, I'm referring to Earhart's treatise, section 9.703, opinion on the ultimate issue. I'm on page 933. Testimony in the form of an opinion or inference otherwise admissible is not objectable because it includes an ultimate issue to be decided by the trier of fact. And in that section 703.1, it talks about that opinion testimony is not inadmissible solely because it includes an ultimate issue to be decided by the trier of fact. The provision is equally applicable to expert and lay witnesses. The jury has the power to accept or reject the testimony of expert or lay witnesses and is not bound by their conclusions. Merely because the witness expresses an opinion to an ultimate issue does not compel the jury to find that the facts to be true. The jury will be given the opinion. The jury will give the opinion as much weight as it feels the opinion deserves. Then it goes on. The abolition of the rule against opinions on the ultimate issues does not mean that all other opinions are admissible. Witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case. Witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury to determine what occurred. For example, a witness cannot express his or her opinion as to the guilt or innocence of a criminal defendant. Then I'm on page 940, 703.1 still. When a witness is asked to express an opinion that applies a legal standard to a set of facts, which Dr. Warner did, the opinion testimony is generally inadmissible. The danger is that the witness will apply a standard or definition which is different from that defined by the applicable law. The application of erroneous legal standard results in the opinion testimony being misleading and not helpful to the jury. For example, an expert cannot opine whether a nursing home was negligent in its care of the decedent.
That's exactly what we spoke about at counsel's table.
I know, Judge, but if you go on, it says an expert may not be permitted that a truck driver drove in a grossly negligent manner, whether the sheriff's conduct was unconstitutional, whether certain waters are navigable, whether the defendant's action constituted misapplication or concealment of funds, or the legal obligations of the parties to a contract, whether the testimony of the expert is a permissible factual conclusion, or the impermissible application of a legal standard or definition to a set of facts is sometimes a fine distinction involving a large measure of discretion with a trial judge. For example, the admission of expert testimony that certain investments, it goes on. However, the witness expresses an opinion about the intent of the accused. The opinion, this is one of the important sections. However, if the witness expresses an opinion about the intent of the accused, which Dr. Warner did, the opinion has not been permitted. The distinction drawn by the courts as to when this type of opinion testimony is admissible are often not clear. Section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. This expert testimony regarding substantive legal principles may not be helpful to the jury and may create confusion if an expert testifies in a manner that is different or even in conflict with the testimony of an opposing expert.
But the citations, respectfully, Counselor,
If I could finish.
respectfully, Counselor, the citations that you're referring to are not at issue. Fluellen, error to permit arresting officer to.
He said, respectfully, Counselor. Respectfully, Counselor. That was good.
Testified that a quantity of cocaine possessed by appellant indicated that he possessed with intent to sell, which is a specific element of the charge in that case. Gamble. Officer's expert testimony with the amount of drugs found in defendant's possession was inconsistent with personal use and therefore intended for sale was inadmissible. 6447 second 1376 by 4 Gamble and Fluellen 703 7 second 511. The Dinkin case that I read says this is acceptable. If a psychologist or psychiatrist can testify that someone is not mentally defective or was mentally defective, that's on all fours with based on what the defendant had said to this expert. She was not in imminent fear. Now, I don't remember exactly what was said, but it was along those lines, based as looking all those things, the totality of the circumstances of what, in my evaluation, on or about October 2, that the defendant had said to me as the expert, it's not imminent fear. That opinion is not inadmissible per the case law under Dinkins.
Judge, can I read a little bit more?
If you're just going to.
He said, do you want to play the case law chicken game? Because I can play the case law chicken game. And I will win. Incredible display of holding power.
I'm just going to be reading from the treatise. I've already read it.
Okay, well, I just want to make mention, because it's talking about does not prevent a witness to testify about legal conclusions or express opinions on questions of substantive law. And I was about to finish this section. When this testimony, and I'm on page 947, this testimony may also interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. As we know, we're going to do battle over the jury instruction on justifiable use of deadly and non-deadly force. The testimony from Dr. Werner, and I wrote it down. She said, based on what Sarah Boone told her, she was not facing imminent risk of harm.
Right.
That invades the province and function of the trial judge to determine the applicable law and to instruct the jury otherwise, which we haven't even done yet. You haven't made findings of law about which instructions apply. That's what she did, Judge.
Your objection's been made for the record. The court previously ruled on this matter. I appreciate the additional argument, but the court's reliance on Dinkins remains. Just because 9703 speaks for itself. So your objection is overruled as to that issue. Anything else we need to address, Mr. Owens, before we bring back in our panel?
No.
State?
Nothing. Thank you, Judge.
Okay, let's bring back in our panel.
Wow. Wow. That was incredible. That was incredible. That was incredible. Oh my God. Just looking like in my, I can't. It's. I don't know. That's so weird. I'm not muted. It's so weird. At least kind of perfect time. Yeah. Yeah. It's so weird. Oh, wait. Can you guys hear me now? I feel like maybe you might be able to hear me now. But either way, I do have to go. It's working. Okay, cool. That's so weird. I don't know what happened. Either way, I have to go. I will be back, I'd say maybe like an hour. It's 2:30, maybe like 3:30. We can finish up the day. They're gonna bring the jury back in. Hopefully things go smooth and they can just kind of boom, 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 get through some stuff. But yeah, so I'll be back for part 2 in a little bit, and I will try to remember what I was going to discuss and maybe discuss that because I was going to say it's refreshing to see a court stand on business the way that he just did. Judge Kranick is like, he's an example of a very good judge, in my opinion, just through this entire process up into this very tipping point. This was a big deal. This was a big tipping point. This was a big fight that Mr. Owens decided to battle. And yes, it will be a battle of the experts. It will be a battle of the experts, but also it will be a battle of the actual physical footage and evidence that they have. And I mean, I know how the jury is going to interpret all of it, but I also, in this very moment, like going back in time, I also feel like I know how the jury has already been interpreting everything. So I'll be back soon. I'll see you guys in a little bit. Goodbye. Technology. I can't with technology.